The following is a presentation of the exculpatory factors and evidence in the case of McNatt versus Texas. The following sample of information has been gathered during an independent investigation beginning on June 8, 2024 to January 1, 2025. The original arrest of the defendant was on November 30th of 2016. The names of undercover officers are depicted as initials, as the city of Pasadena has deemed their names confidential to preserve officers' safety, despite their presence on public court record. Nevertheless, facing threat of arrest, I will not disclose the names of the undercover officers, but they remain in trial transcripts, and any person can seek other records containing their identities by using the Harris County District Clerk's website record search portal. The critical evidence used against McNatt. In this case is one letter describing instructions for hired hitmen allegedly written by McNatt, an index card with personal information of the two would-be victims, Maravik and Mary Grace, alleged to have been written by McNatt. It's important to inform you, the letter and index card were not certified or authenticated by a handwriting analysis expert at trial. This evidence originated from a friend of McNatt named Edwin Kent, who claimed to be an ex-Navy SEAL and produced the evidence during an unrelated disturbance call the Pasadena police responded to. Other key evidence used is poor-quality audio recordings of 2 meetings with undercover officers, which were not transcribed for trial. As Undercover Officer J.P. testifies in Volume 3, page 187, that they didn't have the time, much less the money, to go pay for somebody to put all this into a transcript. But evidently, it seems the city of Pasadena does have the time and money to conduct an undercover investigation that goes to trial in order to attempt to sentence a man to life in prison using poor audio recordings in modern-day 2016. In these audio recordings, McNatt's voice is hardly audible, and no clear incriminating language is heard from him. The police officer's testimony is used to clarify the language and context of the recordings. McNatt did not receive a copy or recording before trial, a violation of Article 3914 and due process. McNatt does not testify as recommended by his counsel, Tommy LaFawn. The police reports were not introduced into evidence despite how heavily the court relied on testimony pertaining to these police reports, which is a violation of law and civil rights and Article 3914. Immediately after his arrest, it appears, in my opinion, the police made sure he could not defend himself with a private attorney by seizing his property at his home. It is not known if they had obtained a proper warrant, as they have refused to disclose records, but the Pasadena police came into his home, photographed various items, and broke into his safe, Volume 4, page 49, and Volume 1, page 8, and seized many gold coins, jewelry, family heirlooms, and cash estimated to be valued up to $100,000. All which were not involved in the alleged crime, nor were introduced in trial as evidence. Thus they are subject to release to the defendant, just as how they release his truck. But the Pasadena Police Department has engaged in evasive tactics to prevent the defendant from getting his valuables, delaying the disclosure of even the most basic records the defendant is entitled to under law. The defendant only managed to obtain the police report when the Attorney General got involved and demanded Pasadena disclose the record. Although they still redacted most officer names, and only through the use of the context provided by court transcripts can some of their identities be ascertained in the reports and the state's key witness, Edwin Kent. Now, Pasadena will not answer their phone in City Hall, their legal department, records department, or the property room, or come forward to the property room window, or call the defendant back or respond to emails. Internal Affairs Sergeant Kenneth Urban has been contacted, and he no longer will respond. Calls conducted and not answered have been documented and recorded as evidence. Now, the following is a summary of some of the lies, inconsistencies, and contradictions in the false testimony between the state's witnesses, facts of the case, police report, and the prosecutor, Samantha Connect. The prosecution starts the trial with direct examination of Officer McGregor. On Volume 3, page 21, Connect asks McGregor if one of the officers with the Pasadena Police Department brought a possible solicitation case to his attention on November 20th or November 21st. He answers yes. But later on Volume 3, page 34, during his cross-examination under defense attorney Tommy LaFawn, McGregor changes his story to him being assigned the case on November 8th, which is what is stated correctly on his previously unavailable police report, page 35. Additionally, in the list of police reports in Undercover Officers, TN's report, page 6, he states that on the 21st of November, we received information from Detective McGregor. Although in McGregor's report, page 36 to 37, he stated he contacted the undercover officers on November 19th. On Volume 3, page 15, in Kinnick's opening statement, she states the initial tip and the prompt start of the investigation was on a nondescript date in October, when Edwin Kent approached officers during an unrelated police response to a call about a disturbance. What she doesn't say is this disturbance was at his home at 3809 Meadow Lake Road in Pasadena, Texas. During Kent's direct examination, Volume 3, page 44, he states the disturbance was at his house, but gives very little details on why the police were present, and testifies he showed the police text messages and a letter and a note alleged to be written by McNatt. Further, during the direct examination of Edwin Kent, Volume 3, page 44, he testifies he came forward in November. And during cross-examination, Volume 3, page 65, Kent also testifies that he was buying time as instructed for detectives in September. In Volume 3, page 66, he elaborates he did this because of Thanksgiving holiday break to buy time. But obviously this is nonsensical, as Thanksgiving is in November, not September. Kent miraculously is not held in contempt of court for this inconsistent testimony, now spanning the start of the investigation from September to November, 3 whole months. Tommy LaFawn does not address this, and appears to lead the witness to correct his testimony. This further undermines the credibility of the state's timeline, and brings to question the motives of defense attorney Tommy LaFawn. Also during cross-examination, Volume 3, page 51, Kent elaborates that the police responded to a call he allegedly made about a fight outside his front yard between his girlfriend's brother, who is possibly a man by the name of James Ketchum, and an unknown person who he did not elaborate on their identity or any identifying details. Now this is the call for service requested by McNatt in December of 2024, which is being delayed and set off by the inappropriate and unlawful abuse of the Attorney General's public information disclosure review process. The defendant is not at all asking for sensitive or confidential information. This is a call made about a fist fight outside a home. He only needs the date of the call and who was the two individuals fighting. It is completely unrelated to the criminal case, and only serves to corroborate the timeline of the testimony of the initial complainant who kick-started the investigation with his false allegations. McNatt believes the Pasadena Police Department is obstructing the release of even this simple, unrelated record, as they know it will completely dismantle the false narrative and timeline constructed by the Pasadena Police Department and the District Attorney's Office. These actions amount to conspiracy and obstruction of justice. McNatt also believes that in fact it was Edwin Kent who was the stranger in a fight with his girlfriend's brother, and he injured him and feared legal repercussions. As Edwin Kent told him of the altercation and asked him his opinion of the legal implications before McNatt was arrested. Therefore, McNatt believes he made these false allegations seeking leniency. Additionally, even if this scenario didn't occur, it is highly suspicious how shortly after trial, in June of 2019, Kent was indicted for sexually assaulting a 13-year-old and only received deferred adjudication with probation for 6 years, and is now a registered sex offender. The basic records do not seem to be available on the district clerk's website. Now, when the record of this call for service was requested, the Pasadena Legal Department submitted ludicrous claims in the brief to the Attorney General's office, such as what was being requested was sensitive information in regards to minors, and sensitive graphic crime scene photos such as persons decapitated, dismembered, and mutilated. Also citing a request for information of the identities of undercover officers and information that would reveal undercover tactics used by police. These claims are false as it was communicated that the call for service record was the main focus of the request, and they are to redact what they deem sensitive. Not to inappropriately attempt to characterize the request as a demand for the entire record. And to my knowledge, no undercover officers should be involved in what was stated to be a call about a fistfight. This is clearly an attempt to falsely characterize the request to the Attorney General. Back to McGregor, he is further cross-examined and asked if he had any text messages back and forth with the prosecutor Connect. He answers that it's possible, and on page 35 he states he doesn't have those messages anymore and did not preserve them, further undermining the credibility of the case. It is to be noted on McGregor's police report, it has much information not included in the trial. Such as in page 35, he instructs Kent on November 8th after speaking to Samantha Connect to obtain incriminating audio recordings of McNatt in order to further the investigation, thus contradicting the claim by Connect in her opening statement, Volume 3, page 16, in short, that the letter is what triggered the investigation. That is false, as clearly in McGregor's police report, page 35, he was only reviewing a report in regards to Kent's claims filled out by Officer Riddens as a concern for welfare complaint. No urgency seemed evident, as they didn't collect the letter that was allegedly presented to officers that night. Further, in McGregor's report, page 35, he tasked Edwin Kent to gather incriminating audio with his cell phone on November 8th, in the same capacity an officer would instruct an informant. On November 11th, Kent reported back via telephone stating that he had failed to gather the recording for reasons that cannot be deciphered from the redacted police report, but then states to McGregor that he obtained instructions for the hitmen characterizing it as new evidence, as he didn't turn the letter and index card when he spoke to McGregor on November 8th. It appears that Kent, having failed to obtain the requested audio, substituted this letter and index's card in a desperate attempt to gather evidence. Kent's desperation to produce evidence and the inconsistencies in his narrative cast doubt on the legitimacy of the letter and index card, and suggest that he may have fabricated or tampered with them. Despite this, the prosecution continued to rely on these items as critical evidence against McNatt. Further on the police report, page 35, McGregor states he then contacted Connect on the failure to obtain audio, but that he obtained the letter and recommended that he could have the narcotics team obtain the audio, and subsequently Connect agreed. This entire investigation appears to be riddled with failures that ultimately transformed into what seems like a conspiracy to frame, coerce, and entrap McNatt. When the police and prosecution failed repeatedly to gather admissible evidence with a proper chain of custody, they resorted to using improperly handled evidence or fabricated evidence, such as the letter and index card, to build their case. As any reasonable and prudent officer or prosecutor would acknowledge, evidence like the letter and index card, if not collected immediately and subjected to a proper chain of custody, cannot be reliably attributed to McNatt. This makes them inadmissible at trial, which highlights Pasadena's refusal to reasonably comply with the request. Edwin Kent further testifies under Direct Examination Volume 3, page 42 to 43. In October-November is when McNatt approached him with the proposition of having the women kidnapped, sexually assaulted, and killed, but didn't take him seriously until he suddenly produced names and addresses for him to give to fictitious people Kent had fabricated. Named Samson, David, and Goliath people he claimed to have invented in order for him to buy time to figure out what to do, but never called the police. But this completely contradicts his testimony. In Cross-Examination, Volume 3, page 63. Edwin Kent says he requested the information from McNatt, stating his fictitious operatives were requesting it, contradicting his earlier testimony that McNatt approached him unprompted. Again, Tommy LaFawn does not preserve his point when exposing Kent's false testimony. And notably, as stated earlier in Volume 3, page 65-66, Kent says a similar excuse that in September, he pretended to be in Skype contact with these individuals in order to buy time under the instruction of Detective McGregor. This inconsistency in testimony and pattern of excuses suggests that the investigation had been conducted much earlier than documented, further leading to further speculation of a possible conspiracy among the officers and district attorney to falsely convict a man. Kent also states on Volume 3, page 7879 under cross-examination by Lafon Kent, states that he is not sure how officers made copies of the text messages between him and McNatt. Only that he knows they did it somehow. When asked if he still has the same phone, he says no. When asked where the phone is now, he answers, "I don't know." These messages were never produced as evidence. This insane evasiveness is not addressed or brought attention to, and he is not held in contempt. On Volume 3, page 4445, Kent also states he turned in the letter and index card in person at the Pasadena Police Department, which could only mean he had not surrendered it at the scene of the disturbance where he alerted officers. It is highly questionable that officers would not collect such critical evidence for such a serious crime and allow a man to walk away with it. Kent also conveniently does not state how much time passed or the date of when he turned the items in to Officer McGregor. It is curious that in the police report made by McGregor Police Report page 35, McGregor notes the date as November 11th. Kent turned over the letter only after a call on November 8th, but also does not mention any index card being turned into him, further casting doubt on this narrative and the chain of custody of the index card, and how it was introduced into the investigation. Furthermore, as mentioned in report page 35, he states that he had a phone conversation with Kent on November 8th, which is the earliest date seemingly accurately recorded, so subsequently at best 3 to 4 days passed before Kent turned the letter in, but regardless the chain of custody is broken and questionable, especially as the earliest month that was stated in Connect's opening statement of the night of the disturbance where Kent reached out to officers was October 2016 in Volume 3, page 15. Further casting doubt on the narrative strung together by the prosecution. Volume 3, page 49, when asked if, once he received the letter, is that when he promptly showed it to the officer and then gave it to McGregor, he answers yes, but this contradicts the aforementioned facts. It would not be possible to give them the letter promptly when McGregor speaks to him on November 8th after reading Officer Ritting's concern for welfare complaint, and Kent comes in on November 11th. In Volume 3, page 50, Kent states that after meeting McGregor, he then contacted McNatt and told him that there was going to be a meeting set up between Samson Goliath and David, and he would let him know when. Kent then got back in contact with the McGregor, and McGregor told him the meeting details. Then Kent relayed that information to McNatt, stating effectively he was the point of communication between officers and McNatt. But Kent states that after that he does not know what happened, as he had nothing to do with the investigation after meeting McGregor by saying, "After that, I was out of it." This contradicts his later testimony when asked under cross-examination Volume 3, page 72, if he had seen McNatt face-to-face after his first meeting with undercover officers. Kent states under oath no, and shortly after in Volume 3, page 73, when asked simply if he just spoke to McNatt on the phone. Under pressure, Kent tells the truth as he slips up and admits he went to McNatt's house after the first meeting and states McNatt was upset. Once again, Lafon does not preserve the point, nor calls Edwin Kent on his blatant lies. Undercover Officer JP's testimony later in Volume 3, page 88, also contradicts Kent's testimony on having no involvement in the investigation after meeting McGregor as stated in McGregor's police report was November 11th. But in cross-examination Volume 3, page 32, McGregor himself says he called Kent back post, meeting him on November 19th. Furthermore, Undercover Officer JP testifies that he spoke to Edwin Kent on the phone, but McGregor claims to have informed the undercover officers on November 19th. Therefore, Kent's testimony is a lie. He definitely continued to be involved in the investigation. Even more incriminating in Volume 3, page 7071, when asked if he ever had the contact of the undercover officers. He denied this, but this is in direct contradiction to Undercover Officer JP's testimony, aforementioned on Volume 3, page 88, where Undercover Officer JP stated he called Kent on the phone. Thus he is unequivocally lying, and also they could have remained in contact with each other. Undercover JP's also only states that he spoke to him about the letter, never mentioning the note, which is accurate to the police report, page 35. where McGregor only documents receiving the letter and processes it as evidence. So far in these testimonies, it has been revealed that Prosecutor Connect, Officer McGregor, Edwin Kent, Undercover Officer TN, and JP have all had communication with one another that was not preserved in order to be presented as evidence at trial. This is concerning, as this undocumented coordinated effort among these individuals during this investigation appears to amount to conspiracy, official misoppression, and the subsequent actions of the District Attorney's Office and Pasadena Police Department post-McNatt conviction can amount to the definition of a continuous criminal enterprise. Volume 3, page 75, during cross-examination, LaFawn asks Kent if he ever told anybody that he was previously a Navy SEAL. And he answers possibly, which is a bizarre answer to admit to stealing valor. Then on Volume 3, page 76, he states, "I don't remember, but I never told anybody I was a Navy SEAL." This cast immense doubt in the credibility of Kent as a key witness for this case, as he has been nothing but deceitful, evasive, and inconsistent with his testimony. Yet Tommy LaFawn does not admonish him, nor preserve his point, nor ask for Kent to be held in contempt. It is notable again that never in the trial was it ever revealed that McGregor instructed Kent to obtain incriminating audio recording of McNatt in order to further the investigation, as instructed by Connect in Police Report page 35. The trial continued. The only other evidence is audio that is noted on the court transcript many times as garbled or hard to hear. Volume 3, page 94 and 180, and Volume 4, page 105, 115, 118, and 122. Any reasonable person would conclude it is absolutely ridiculous to solely rely on garbled, unhearable, bad-quality audio recordings to convict a defendant.